Femi Falana, Senior Advocate of Nigeria, is live for us on the program. Thank you so much, Leonard Sik, for joining us tonight on the program.
Thank you very much.
I appreciate it. Let me get your view first and foremost on these Rivers political crises. Give us an understanding. So we have about 4 of the pro-Fubara, pro-governor of Rivers State lawmakers. And we have, on the other hand, the 25 who are on the other side, who are the pro-Wike lawmakers in the House of Assembly, and all of the drama that have played out. Underlining all of this is the fact that if there is an impeachment proceeding to be instituted or carried out on the governor, we saw the emergence of the factional speaker out of the 4, and that those will be asking the question, who is the real speaker? From the point of view of the law, what is your assessment, Ms. Falana?
I think the matter is already in court. I think a couple of days ago, the High Court sitting in Port Harcourt granted an order of injunction restraining the 25 lawmakers from parading themselves, as members of the Rivers State House of Assembly on the ground that they had decamped and thereby for now have forfeited their right to be legislators. I think what will be required of them is perhaps to go to the court and join issues. Before now, they were threatening impeachment. And of course, the governor was likely to have challenged their local standard to begin impeachment proceedings since they are deemed in law to have lost their seats. Frankly speaking, I think they were not properly guided or advised. Because unless you can show or demonstrate that there is a division in a political party that sponsored your election, you cannot remain in any legislative house if you decamp or cross to another party. Because the whole idea is that the Constitution set out to ban or prohibit political prostitution on the part of legislators in Nigeria. So as of today, there is a court order restraining the, I think 25 of them from parading themselves as legislators in that state, and the speaker from parading himself as the Speaker of the House. That is the law today. So I do hope that those who are affected by the order would like to urge the court to have another look at the case. However, it may be very difficult to persuade the court to allow them to remain in the legislative house unless they are prepared to go back to the people and have their mandate, renewed by the people. So that is the position of the law.
So in all,
and the Supreme Court has made this point clear in the case of Abegune and Labour Party. You cannot, on your own, decide that there is a division in a party, and it doesn't mean a division in a local government or in a state. It has to be a division down the line at the national level. That is the position of the law.
So where does the people, where do the people stand in all of this? Because the bottom line is the effect of these or an implication on governance. Now, we're seeing an executive order instituted by the governor on the House of Assembly, removing their sitting venue from the where you understand what happened to their sitting venue, which got burned, and now they've removed it and taken it to the government house. What do you make of this? Can the governor do that? Can the governor do that?
Frankly speaking, I would like to again I would like to assume that the governor issued that executive order before the intervention of the High Court in Rivers State. The House is independent of the executive. So with the full respect, the governor cannot tell the House where to sit. This was very clear in the case of, the Oyo State case, which led to the impeachment of Governor Ladoja, whereby, under the influence of the late Chief Lamidi Adedibu, the House was alleged to have sat in a hotel. And the Supreme Court made the point abundantly clear that an impeachment carried out in a hotel is alien to Section 188 of the Constitution. So any sitting of the House outside the principle of the House of Assembly complex will not be known to law, will not be recognized by law.
But who determines, Mr. Falana, who determines the complex? Who designates the complex? Is that going to be by a statute or by the decision of the members themselves? Don't forget, there was a disaster that happened to the House of Assembly complex, which made them attempt to take away the venue to another venue, which is now up in the quarters. Now, the governor, as the head of government, does he have the power to designate? Because if he builds another complex today and sites it in Awada local government, for example, or in some part of Rivers State, who determines, according to in the eyes of the law, who determines what the venue of the sitting is?
So there is a House of Assembly complex in Rivers State today. If there is going to be a sitting elsewhere, maybe because of renovation or some other problem, or if the House, assuming the House is flooded, the members of the legislature, the members of the House of Assembly, properly constituted, will have to decide where to carry out their constitutional duty. I mean, for instance, the House of Assembly cannot pass a resolution directing the executive where to hold meetings, or directing a court or the chief judge of the state where the judges should sit. So there is separation of powers under the Constitution, and each organ of the government must recognize its own powers and limitations. As it is today, unless there is evidence, maybe the House has become defective, and the House of Assembly will have to sit elsewhere, and the executive has information to that effect. The information will have to be passed to the House, properly constituted, to now decide, for the members to decide where to sit. But the position of the law is very clear on the sittings of the House, the proceedings of the House, where to hold the proceedings of the House. So in this case, I mean, just like you have said, I think it's important for the gladiators in Rivers State to appreciate the need to take up governance very seriously, settle their political scores, and allow governance to resume in that state, so that the problems confronting the people can be properly addressed.
Mr. Falana, let me get, because there are divergent views. And when it comes to politics, there's also the side of the law and the side of the norm and conventions. And of course, there are kind of necessities when it comes to political conventions. So the president, Bola Tinubu, intervened in the feud we're saying between the Wike camp and the Fubara camp. And there are those who have challenged President Tinubu that he doesn't have the constitutional ground to intervene in the matters of Rivers State. But there are those who say, oh, as a father, a political father, he wanted peace. Give us an understanding. Was the president legally wrong, but politically right? Is that the case?
I think the president intervened at the instance of Femi in Rivers State, involved in the crisis. It's not backed by any provision of the Constitution, mind you. It's an extra legal measure towards the restoration of law and order in that state. But if those who are involved turn around to say we are unable to comply with the resolution signed in the villa, of course there's nothing the president can do about that. The president can only wish them well. And since they have now taken their battle to the court of law, we just have to follow through and allow the law to take its course. That is what the rule of law is about under a democratic dispensation. There's no provision for any grandstanding outside the provisions of the law. And that point has to be made abundantly clear to all the people who are involved in the crisis in Rivers State. But at the end of the day, the people must be at the center of governance. And you know, it's a bit difficult to really speak authoritatively on this now, because this battle is based on ideological differences, as was the case in the Second Republic, whereby, you know, you had Governor Abubakar of Kano State and Balado Musa of Kaduna State, with who disagree fundamentally with the leadership of the PRP. It was based on the implementation of their program and the alliance between their leader and the MPN, the ruling party. He said, no, we're not going to have anything to do with MPN. We want to meet with our colleagues in the Progressive Governors Forum. The matter went to court. And the court said, the Lagos High Court said, yes, you can associate with your colleagues, but you are members of the political party. So you also have to appreciate the need to kowtow to the leadership of your party. Ultimately, both of them were inspired by their party, and they had to contest under different political parties, you know, in 1983. So, but this one, it's not about, you know, ideology in terms of difference. There's not an ideological difference, you know. So people of the same political camp must know how to resolve their crisis in a way that the provisions of the Constitution are made to apply. If you decamp, you cannot remain in the house. That is the law. It is very clear. If you are going to impeach a governor, you must also familiarize yourself with several cases. Governor Ladoja's case, Governor Peter Obi's case, Nyako's case, you know, and so on and so forth. So the law is very clear of Governor Mbagariye. How do you impeach a governor? You must be members of the House. Recognize, and if you have lost your seat, because impeachment is so important, it requires 2/3 majority of the entire state. So the Supreme Court made that point in Dariye's case. Now, if you are going to impeach the governor, the House must be properly constituted. If there are vacancies, there must be fresh elections. So you can't talk of the majority, you know, that will not meet the 2/3 requirements of the Constitution if you want to remove the governor. If you have lost your seat, you you cannot take part in the proceedings that will lead to the removal of an elected governor under the Constitution.
So, Mr. Falana, quickly, so in the eye of the law, Mr. Falana, how many lawmakers do we have in Rivers State? You were saying that as far as the law is concerned, the 25 lawmakers who defected from the PDP to the APC, from your explanation, it does look like you are inferring that they have automatically lost their seat. Is that what you're saying, Mr. Falana?
The 25 lawmakers who defected have lost their seats. They've lost their right to remain members of the House of Assembly. That is the law.
But
the case of Abekunde and Labour Party.
Yeah.
The Supreme Court made it clear, that you cannot become and then remain members of a legislative house in Nigeria unless you can show that there is a division in your party. Today, the PDP is one.
So, Mr. Falana, on the other hand, there are 4 lawmakers. Out of the 4, they chose one of them to be a speaker. Is that legally valid too?
Again, we have to look at the Constitution. Before the House can conduct proceedings, they must meet. There must be the quorum. The House must form a quorum to conduct, the business of the House. And the quorum in the Constitution is defined. But if you want to remove the government by way of impeachment, again, you must have 2/3 majority of the legislature. Again, this is very clear.
The Rivers people are up for a long ride in this political mess. Let me take you away from that. I'll take you to some major national issues. And this is one of the updates I gave earlier on, where the TUC and the NLC said tomorrow they will picket the offices of the discos and NERC across the country based on the electricity tariff hike. And this might be one of a kind of different kind of picketing and protest that we're saying. You have spoken up about the electricity tariff hike, but I will take you to another kind of tariff or levy that the government has since imposed. You have frowned on it, but what the Labour says it will do tomorrow, to what effect, and under the law, what should the government be thinking about in this respect?
Well, there's provision for picketing under the Labour Act, in Nigeria. And that is what the Labour centers will begin tomorrow. They're going to picket the office, the headquarters of the NEC, as well as the offices of the discos, to register their protest against the illegal electricity tariff, increase in electricity tariff, because the Nigerian Electricity Regulation Commission did not follow due process. It did not conduct a public hearing as required by the Electricity Act of 2023. So I do know that what will happen tomorrow is picketing to start some series of protests that the Labour movement may be embarking upon. And I do hope that the commission, that is NEC, will engage, productively. I mean, we'll discuss with the Labour movement and see what can be done to reverse, the hike. Because, again, the increase was anchored. Band A, customers, the increase was anchored on the assumption that there will be regular electricity supply, at least for 20 hours. But, that has not been the case. So, that is another problem with
Mr. Falana,
and the government has said, if a disco cannot meet the requirement, then you are not bound to pay.
Yeah, the federal government is saying through through the Minister of Power that they are unbundling the discos. It does look like there are a lot of anomalies that went on in the discos coming to effect. But NEC would say that they've come down, and some of the discos have, in fact, reduced the prices in which when they at first announced the electricity tariff hike, and they will imagine that the promise made is that the electricity tariff hike will help to stabilize or help the industry or help production of electricity in the country. Can that consideration be a proper thing to do by the government?
You see, Sean, by virtue of Section 116 of the Electricity Act of 2023, you can only justify a hike in electricity tariff if you are supplying electricity. So there must be evidence that there is improvement in electricity supply. But if Nigerians have to power their offices or their business premises with generators, solar power, and of course, epileptic electricity supply, it's difficult to justify because I have to buy diesel at a skyrocketing rate. You have to maintain your generator. You may also have to switch to solar power. Now, if this is the situation, it becomes very difficult to justify. And again, when they talk of unbundling, to the best of my knowledge, majority of the discos have been acquired by the government because of their toxic loans. I think I've said on this program, Shim, that as at the time the discos were distributed and sold in 2013, that sector had become self-sufficient. The government was no longer, subsidizing the sector. So we must find out what happened between then and now. And so if the government is thinking of unbundling again, you must sit down with the workers. You must engage in consultation in the country because privatization has failed woefully in it. I think the Senate had one call on the government to take back all the discourse, and take firm control. So we cannot be increasing tariff when majority of our people are supplied darkness. We're not talking of those in band B, D, and C. We're only talking of band A for now. And there's no basis for such discriminatory treatment of consumers of electricity.
Yeah. Just when we're trying to wrap our heads around the electricity tariff, the CBN came with an announcement of the cybersecurity levy. SERAP and some other organizations have said they've gone to court to sue the federal government, but we are hearing, and we are hoping that the federal government will come out officially. We are hearing that the president may have asked for a withdrawal or a pause or rescission of that decision by the central bank, the directive, which they say it will take 2 weeks to take effect. What is your opinion? There are those who say this is in our laws, it's in the statute, in section 44. They're just acting based on the law.
Well, the interpretation, as I did say, the interpretation of the amendment to the Cybercrime Act by the central bank was grossly misleading. Whereas the amendment that took effect in February only specified that some businesses that are listed in section 42 of the Principal Act were to pay the levy. But when the central bank issued a circular
And Nigerians were told that individual customers were also going to pay. And I said, no, this is not what the law is saying. And I think the House of Reps also passed a resolution urging the central bank to have a rethink. I want to believe that the government has looked at the law and decided to cancel the levy, or rather suspend the levy. I do hope that the government will make an announcement on that, because such an announcement will be in line with the provisions of the Act. But Shehu, I also think, particularly for you guys in the media, you must be interested in the amendment beyond the levy. That's the 0.05% levy. In line with the decision of the ECOWAS Court, in the case of SERAP and the Federal Republic of Nigeria, the National Assembly amended Section 24 of the Principal Act to decriminalize certain provisions, certain sections, subsection of that section, to ensure that cyber stalking, and others were taken out of the law. So what you now have is a situation whereby you can only be proceeded against if you're engaged in producing or distributing pornographic materials, or a text message or a WhatsApp message that can lead to a breakdown of law and order. Again, that will have to be defined at some point. But there's also Section 38 now, which has been smuggled into the amendment to justify breach of or data privacy. Again, this will have to be looked at vis-a-vis the provision of the Constitution, Section 37 in particular, the right to your correspondence, the privacy of your home, and the general interpretation of Chapter 4 is that you cannot breach any provision of Chapter 4 without a court order. If you are going to detain me, even as a suspect, you must go to court and get an order. If you are going to prevent me from traveling out of the country, from enjoying my freedom of movement, you must get an order. If you are going to seize my property, even in interim, you must get a court order. So if you are going to breach my right to privacy, data privacy, you must get a court order, that hasn't been considered by Section 38 of the Act, I think this is an area that the National Assembly will have to have another look at.
Yeah. Let me take you quickly and get your view on what happened between Osun State and Lagos State. And we've seen something like this happen between Lagos State and Anambra State. I remember a similar thing, or those debates happened when Raji Fashola was governor of Lagos State and Peter Obi was governor of Anambra State. But this time around, between Babajide Sanwo-Olu and the governor of Osun State, Ademola Adeleke. Now, about 317 youths were transported.
371.
371, yeah. Okay, thank you. 371 of them taken from Lagos State, and the police has also come into this, and also the Lagos State government to say they picked some of these people in different parts of Lagos State, and they took them to where they belong, legally speaking. Give us your view on what happened or what transpired, because this thing keeps happening again and again.
Well, in 2013, when the Babajide Fashola administration expelled some, beggars and destitute from Lagos, I did protest and made it clear to the government at that time that the government has no power to remove any Nigerian and expel him or her, because every Nigerian has the right to take residence in any part of the Federation. You have freedom of movement. So if you are going to be taken out or expelled from the country, again, from any part of the country, you must have to go to court. And it's not possible to expel a citizen of this country within Nigeria or outside the country, as you saw in the case of Sugar Bar, you know, in the Second Republic, where the ruling party decided to expel the majority leader of the House of Assembly in Borno State and, you know, dump him in charge on the ground that the government then didn't believe that he was a Nigerian. Of course, you know, he challenged the deportation and the court ruling is civil, and he was brought back to the country. Again, in Nigeria today, it's a war against the poor. It's a war against the poor. Those who have been expelled are said to be miscreants. Sometimes you call them hoodlums during elections. This time around, they are miscreants. You know, now it is the duty of it is the government that creates hoodlums and miscreants. And so the government is required in a place like Lagos, you know, to engage, get beggars and destitutes, you know, to be taken care of. And I do hope that Governor Adeleke of Osun State, who has expressed concern, will collaborate with his colleague in Lagos to have those citizens brought back if they want to return to Lagos. But as far as the law is concerned, no government has the power, not even the federal government, has the power to expel any Nigerian, you know, from where he or she wants to reside. That is the law.
All right.
And that is my position. Those guys have to be brought back.
All right.
And again, it's not Lagos. It's not the Lagos affair alone. If they call it renewal or ban renewal policy, which only affects the poor, the rich. I mean, members of the elite from Osun State who are also jobless in Lagos are not going to be expelled. You know, it's only the poor that are affected by such, you know, policies. And that is why Nigerians must speak out. And that will what will also interest you, Shehu, is that none of the Yoruba irredentist groups are spoken against because we are dealing with the poor. You know.
All right.
So, but I hope it won't happen again.
Yeah. Thank you so much, Mr. Femi Falana. I appreciate giving us all the legal insight into all of these issues. Thank you so much indeed for your time tonight. I do appreciate it.
Thank you, my pleasure.
Bye-bye.